Greetings. Welcome to a podcast with Amar Jain, sir. He's an accessibility professional and a corporate lawyer. And this is Tejas Ardari, a student at Ramaya College of Law. We're delighted to have you today with us, sir.
Thank you.
Sir, I think the best way to start off today's conversation would be to talk about your profession, how you started off your profession, how was your college life?
Well, as you know that I'm a lawyer by profession. I did my schooling from Jodhpur, Rajasthan, and then I moved to Mumbai to do my law, 5 years law from Government Law College, Mumbai. And during my legal education, I realized the different avenues that are available to a legal professional post the completion of a BLS LLB or the relevant domain. And I decided to choose law firm as my starting point, and which is when I got into trilegal, initially in banking and finance, and then capital markets, and then I moved to Cyril Amar Mangaldas, again into capital markets, and I worked with law firm for 7.5 years. Post that, I worked briefly in contract management in an in-house company, and then I started my own law firm as well as an NGO.
Mm-hmm. So where did you enjoy working the most? Everyone has their own preferences of where they would have loved the most to work. So did you have any certain preferences, or did you just enjoy it in general?
I think the answer to this is slightly nuanced, because if you ask me as a beginner, my best learning curve was my journey with law firms. That made me professional, that made me realize what are the good qualities of being a good legal professional. Each journey makes you learn something new, right? So negotiation also was quite interesting, because that teaches you how to be calm in the most difficult situation. And then I also currently enjoy my stint with the litigation, both in my capacity as a mainstream legal professional, where I'm dealing with laws like property, family, among others, and as well as my stint as a litigator for the causes of persons with disabilities.
So why the shift from corporate law to litigation, sir? Did it pique your interest?
I am very keen to learn newer aspects of the profession that the profession offers. So when I was with law firms, I learned how to structure transactions, how to negotiate agreements, how to do due diligence, how to interact with clients. Then I thought that this is one skill set that you acquire during your journey. The other skill set of being an on the spot thinker, knowing when to stop to argue, knowing when to argue, knowing when to push back, or knowing when to walk out, are a couple of traits that you learn as a litigation lawyer. So which is why, to be able to gain in-depth understanding of what each field offers, I chose to pursue even litigation as my career profile.
So you wanted to broaden your understanding and horizons.
Yes.
Right, sir. Right, sir. So, sir, the first thing that anyone would think of when they jump from corporate law into litigation is, how exactly do you balance it? Because everyone has their own personal life. They have to take care of their career as well.
Right.
So did you find it hard? Did you find the transition to be hard?
See, honestly, as a corporate lawyer, I had acquired the skills of, as I said, drafting, negotiating, etc. So the understanding the intent of why you're doing and what you're doing was very clear to me. But as a litigator, as I said, you need different skill set of knowing the application of law, of knowing the legal propositions that you can rely on, of knowing how to research and be crisp with your judgments and arguments in courtroom. That's a different ball game. How to keep yourself calm when the other side tries to push you into a single direction. How to know the art of reading the mind of the opposite side or the bench, right? So that you can appropriately persuade or push your argument into a specific direction. This part of learning this skill set as a transition was definitely a learning curve. I won't call it a difficulty, but it was a learning curve for sure. No matter, despite me having spent 7.5 years in corporate law, the first court appearance was a feeling of being nervous. So because obviously it was a new ball game altogether. So that transition definitely is something you acquire the skill set over a period of time. The other aspect was the sustainability, because in a corporate you had fixed income coming in from your professional sources. In litigation, and especially when you start something of your own, your mindset changes from being a professional consultant to being a business owner, because you need to generate business for your own self so that you can grow at the pace you want to grow at. So that was a learning curve for me, and definitely it had its own share of challenges.
Understood, sir. Understood. But do you think this transition has helped you in your career, or apart from broadening your horizons, do you think it has helped you in any other manners?
Definitely. If you look at the skill set that you acquire, if you look at the skill set of running your own business, to know which opportunities are the ones where you want to monetize, which are the opportunities where you want to contribute, um, which are the places where you may want to solve the problem through a different approach. For example, not everything has to be solved through courtroom. There are things which you can solve through policy lens. There are things that you can solve through dialogue. All of these things wouldn't have come to me as a learning curve unless I would have chosen to be into litigation. So beyond the typical challenges, these skill sets I would have definitely not acquired had I not been in litigation.
Right. So, since we are now talking about litigation, let's deep dive into lawmaking and execution of laws. Do you think that India has significantly improved in these couple of years with regard to lawmaking, judiciary, judicial decisions that are passed? So, do you think that India is making a significant improvement in terms of law and justice?
It's a very good question. Over a period of time, if you see the drafting trend and the trend of implementation has changed. Earlier, laws used to be very prescriptive, leaving very little room for flexibility to implement in a particular manner. But I think ever since newer laws started getting drafted, a lot of powers were given to executive to refine, readjust, redefine within the boundaries of the law the process of implementation, the ability to be able to plug in the practical gaps that may have been have remained while drafting a statute. Those are the nuances which lawmaking went through itself. When you see implementation part of it, we still have that problem, I won't deny, where we have best of the laws on the books, but implementation is either patchy or there are various loopholes that need to be plugged. But definitely we have improved over a period of time, because the monitoring ability of judiciary has also increased manifold. Judiciary has been able to monitor laws for implementation. Judiciary has been playing a compliance watchdog function as well. That has given fillip to implementation, in my honest opinion. The judiciary has its own share of challenges, where getting right assistance from the lawyers of all sides, making sure that material is made available in timely fashion, making sure that the orders passed by the courts are complied with in the right spirit. These are some of the challenges. But over a period of time, judicial pronouncements have brought more clarity in their application, more practicality, and more interlinking with the social and economic conditions of the society.
So, do you think when judiciary is burdened with a lot of functions, as you mentioned, watchdog, don't you think it also affects the number of cases that are disposed? Because pendency of cases is a major problem in India. So, how do you think the judiciary would like to take care of the pendency of cases?
You see, the pendency is there for a reason, not just the fact that judiciary is definitely burdened with lot of cases, because many a times you see cases which are not as meritorious as other cases but still keep going on for years and years. That is one angle. The other angle is there are so many procedural aspects which allow you to delay a matter for indefinite periods. The practice of seeking adjournments, the practice of not filing records on time, the practice of arguing without realizing how much time you are consuming on a given point, even though the point may be not so much of worth consideration by the judges, are couple of things which are slowing down the pace at which the justice can be delivered honestly. So there is a need for procedural enhancements, there is a need for data integration across the judiciary, there is a need for bringing discipline in the profession in terms of making sure that timely records are filed, making sure that the cases are given the amount of time which they deserve, making sure that each counsel has an allocated time beyond which they should not be permitted to argue, making sure that the quality of briefs and written submissions or notes for the hearing which you carry along with you to hand over to judges are of good quality, so that judges are able to derive assistance from what you are doing, and it should not be that judges are left to struggle on their own to figure out what is there inside a paper book. Also, usage of technology in the right manner. For instance, nowadays a lot of reliance is placed on AI technology, but we know that AI can only do the job up to a certain extent. It can't take away the human thinking ability, which is what realization I think is missing in the fraternity. So those are many areas where there is a concerted need for taking appropriate measures. And lastly, also the sanction strength of judges and availability of courtrooms and the judicial infrastructure, I think also is an important factor which, if improved, can bring lot of expedition in delivery of justice.
So since you're talking about artificial intelligence, do you think artificial intelligence can help in judicial decision making?
See, as I said, artificial intelligence job is to collate the data from all sides, to give entire picture to the decision maker, right? Be it a judge or any other quasi judicial authority. So artificial intelligence can cull out facts, can cull out case laws, can cull out legal propositions, but what it can't replace is the thinking of a human being which is involved when it comes to delivery of justice, or when it comes to decision making power. So that AI can't substitute right now, and I don't think even in near future AI would have the ability to pass judgments which meet the test of constitutionality, which meet the test of practicality, which are also in sync with the societal conditions. That task will have to be done by judges and human as opposed to AI technologies.
Right. So you believe artificial intelligence is only an assistance tool?
Absolutely.
And not a decision making tool?
Yes, yes.
Right, right. So since we are law students, we are budding lawyers, and a lot of legal professionals out there, they mostly choose corporate law, and most of them usually choose boardrooms over court halls. Why do you think people do that? Why do they not enter litigation to begin with?
You see, there are a couple of reasons for it. One, there is this myth in the market that corporate law and litigations are opposite of each other. I would say they are interlinked, because as a corporate lawyer, your job is to design strategy, design transaction structure, design your agreements and other transaction documents in a way where you are able to smoothly execute the transaction and be on a lookout for potential disputes which you can avoid by framing your drafts or transaction documents appropriately, or positioning yourself appropriately. In a dispute scenario or in a litigation scenario, something has gone wrong as part of the transaction. You are now in a dispute situation. That is the time when you, if you know your corporate law side well, if you know how to read the documents, what are the red flags to look out for, you will be able to better present your matter during the dispute situation and will be able to achieve better outcomes. That is one aspect. The other aspect is the corporate law space currently offers a stable beginning to lawyers, to new lawyers, right? because you have a fixed amount of professional income that you are generating every month. You are not worried about how to get business as a starting point. Whereas in a litigation, you are the one who is managing every aspect of, so to speak, business, be it billing, be it administrative work, be it filing, be it arguing, be it appearing, be it managing all other procedural aspects. That's the other factor. The third factor is that today, real exposure during college life to the practical life of being a lawyer, whether in corporate or in litigation, is, I think, still not there. We are teaching people how to be good researchers, how to read judgments, how to apply the law, but we are not teaching people the practical scenarios that one is faced with. So, for example, when you go for your first internship and if you're asked to look at master circulars on or master directions on foreign exchange management, and you have not really dealt with that subject. So, those are the practical aspects which I think are missing. Or, for instance, how to prepare an opinion, how to prepare a memo, how to pick up a query which the client would have posted on a forum and start drafting your own agreement or start drafting your own response. Those are the aspects, and also the softer aspects. As I said, when to negotiate with whom, when not to negotiate, when to push back, when not to push back, how much to persuade, how much aggression is important. All of these aspects, I think, need to be trained and need to be catered to as part of the law school journey as well.
So, since you're into litigation, I mean, correct me if I'm wrong, there are certain times when you do pull back, right? There are certain times when you don't really think of persuading. But in certain situations, it feels like even though you've won the case on paper, you feel like you've lost in reality. Do you have such a case?
It's always a dilemma, to be very honest, because there are two reality checks one has to keep in mind when taking up any case. First reality check is that if the client is able to pay, then am I in a position to say no to that case if the case is not as meritorious as a case should be according to your own understanding of law and your own professional judgment, right? At that time, as much as one should have the ability to say yes in a given situation, if you don't think that it is worth the effort or it is worth the professional pursuit, you should know how to say no, which many of us are not trained at, right? That's one problem. And the second problem is, many a times you are able to get the judgment in your favor, but the implementation gaps remain so much so that the judgment merely becomes a judicial pronouncement without actually seeing the day of the light. In that case, how to be proactive and how to maintain your relationships both as far as getting the right outcome is concerned. And when I say relationships, I don't mean the human connections. I mean your connection with the law, your understanding of the legality, and your understanding of the practical problems and the practical gaps. One is, how do you make sure that you're able to get an outcome by presenting your case in a best possible manner before the court of law. And the second aspect is, once you have something in your favor, how do you work with implementing stakeholders to make sure that it is implemented in the right spirit and in the right manner. That is what you need to learn as an art.
Right. So my question to you is, there are these certain cases that are very sensitive in nature, and certain lawyers pull back from those sort of cases. For example, if I have to put forth an illustration, in the case of there were a lot of lawyers who did not want to protect, if I might phrase it right, or defend the perpetrators. How do you think that works? Because in certain cases, certain advocates don't want to take up the case, but certain advocates do take up the case. So how do you think they would go against their own morals, their own outrage, and defend those perpetrators or the accused?
Okay. Look, when you are looking at a case, depending on who is your client, you need to dispassionately, with a neutral mindset, assess the strongness or the strength of that case without getting into the question of whether it is morally correct, whether it is permissible, whether should I be doing it or not. There can be boundaries that you may not want to cross. If there is something ethically absolutely not something that you would want to take up, it's okay to say no. But always remember, as a lawyer, every person who comes to you is entitled to make his case good before a judge or before a court of law. Whether or not he or she wins or loses is a separate battle. Whether or not he or she is on the right side or the wrong side is a separate battle. It's a question that needs to be established in as part of the trial, as part of evidence, as part of conclusive proceedings, right? Judging someone before the trial has already begun is the biggest mistake that lawyers do, right? So, in my opinion, if you have got a case, independently assess the case on its own merit and then take a call whether you want to take up a matter or not. And don't judge or prove somebody guilty without the proceedings having been concluded.
So do you think the opinions of the public, the media trial, would significantly impact the person who takes up those sort of cases?
Frankly speaking, it's a synonymous situation as other professional journeys, the other technical professions, where public perception, media trial, etc., if it has some evidentiary value, it can be considered, but not beyond that. Because remember, in a court of law, your job as a lawyer is to look at legal principles, is to look at socio-economic reality, is to look at theories of constitution, various doctrines, various principles, various pronouncements, and accordingly prepare and prove your case one way or the other. The perception of the public, the opinion of the public, the media trial, etc., should not be a guiding factor in how you think about a case. Because if you are driven by perception and what public feels or what media feels or what somebody else feels, then you are not doing justice with your own capability to be a lawyer.
Right. Sir, my question, to be very brief, do you think law and justice go hand in hand? Can you achieve justice through law? I mean, if you think of about the concepts of legal positivism, a rule that is legally valid is morally unjust. So, if you want to achieve justice, there are certain times when you cannot do it through law, but can only do it through human sentiments. So, what do you think about that?
See, law is enacted for the purpose, and that purpose is to provide justice in a given situation, right? Whether something is moral or immoral is a separate question. It's a question of societal thinking. It's not a question of legal thinking. Legal question would be whether what I am trying to prove is permissible in the given situation by law or in a situation of rule of law. That's a distinction that one has to keep in mind. So long as you are keeping that distinction, you will never face that dilemma whether something is moral or immoral, because that's a separate conversation for separate type of thinkers. So long as you are aware of this distinction, you will be able to take any case to its logical conclusion. But at the end of the day, every law is enacted with a view to serve justice. So any rule of law which is ignorant of human conditions, human practicality, circumstances, and factual situation is not a rule of law. Because ultimately, as I said, your end game is to serve the people for whom the law is enacted. and that you can't do without knowing all the other factors which go into lawmaking and which then allow you to give a judgment one way or the other.
So do you enjoy reading judgments? Do you enjoy watching court hall proceedings?
Absolutely. Courtroom proceedings and judgments teach you a lot. While judgments will teach you legal aspects, theoretical aspects, etc., courtroom proceedings will teach you advocacy related skill set. Courtroom proceedings will teach you how to handle a given circumstance in a better manner, which if you have watched somebody else doing, you could have done it either the same way or better than what you would have otherwise done. So both have its own learning and both have its own insights.
So just to put forth an experience that I had, in fact, when I interned in the High Court, my senior would deal with habeas corpus cases. And in certain situations, I would come up with questions like, is personal liberty important or is protecting the society as a whole? Because when you talk about preventive detention, that's a very thin line. And in certain situations where the person who hasn't really done anything wrong in the society or to the society is wrongfully confined anyways. So do you think that thin line is very unsafe? Do you think that preventive detention as a whole, the concept of preventive detention is not right or otherwise?
One of the things as lawyers, when you are making an informed opinion about a given situation, which we should not be doing, is to be emotionally attached with the case one way or the other. Because once you are emotionally attached with a case in one way or the other, you will not be able to take a dispassionate view. And this would answer your question in a way where to decide whether the person's personal liberty should be preserved or the detention should be preserved or should be ordered, you will look at the circumstances. As you say that the person may have done it for the first time and his conduct is not to indicate that he is a habitual offender and hence is a good case to be released in a habeas corpus petition, then I don't think there is a dilemma. But if you notice that the circumstances warrant his detention and granting such a liberty would result in miscarriage of justice, then it's a tough call to retain that person in detention. But that can only happen when you are assessing the situation dispassionately.
So what is your favorite case, sir? Which case have you worked on that you personally enjoyed, or which case have you seen or read about that you personally enjoyed?
Well, a very cliche answer would be that every case which comes before you is something that you enjoy. But then there are cases which also make you realize that if in a given situation speedy justice is not provided or a timely intervention is not done, then the whole purpose of case would become infructuous. And in that situation, if you are able to move the needle and if you are able to get the system to act in a given timeline and in a given situation, I think are the moments which make you feel that your life of being able to serve somebody through your skill set is worth living. So those are the cases where I think I get my satisfaction the most.
So you are an accessibility professional, and do you think that how do you think India is right now in terms of accessibility? How do you think the corporate sectors are doing in terms of accessibility? And how do you think Indian courts are doing in terms of accessibility?
Sure. If you see in last couple of years, two things which have happened which would showcase the journey of accessibility. At the one hand, we have had strong policy mandates, strong legal mandate, which would make accessibility as a non-negotiable factor that needs to be complied with. At the same time, we have had very proactive judicial approach to ensure that nobody's rights are denied on account of lack of access. So the needle has moved in the right direction from being an ask which was earlier looked at as a goodwill gesture to becoming a mandate which needs to be complied with, which needs to be monitored on a sustained basis, is the journey that we have traveled so far. Corporates have started taking accessibility seriously because the demand for accessibility has grown exponentially. It is not the case that the earlier times did not have enough demand. It is just that the demands were not so much vocal that it would have been noticed. That is one factor. The second factor is nowadays businesses want to be compliant, they want to be able to cater to all their users, they want to enter into untapped markets to realize newer avenues of business, and as I call it, profit with purpose, right? So as a result of that, there is a lot of traction in businesses thinking about accessibility. Judiciary also has been part of this entire journey, because when an actual user goes to a court of law and says that here are my needs from accessibility perspective and here is what either the court or the government needs to do to make sure that I'm able to participate and at an equal footing with others, they have been very receptive. For instance, the priority hearing in cases of persons with disabilities, both by Supreme Court and by the Supreme Court in terms of categorization and by High Court in terms of ensuring that there is a separate categorization and priority hearing of persons with disabilities cases, is an example of how judiciary has been able to realize that access to justice for certain section of society is still a far-fetched reality, and to make it real and meaningful, these measures have been taken.
Right, sir. So what message would you give to the people who are watching this right now as to how they can conduct themselves with regard to being more inclusive in terms of profession, in terms of treating differently abled people? So what message would you like to give to those audience who are watching this?
Couple of things. Number one, look at the personhood of the person first, as opposed to looking at only the disability of the person. Number two, you need to understand that the person has his or her life which travels through all aspects just as anybody else. Just as you enjoy cinema, I also enjoy cinema. Just as you enjoy travel, I also enjoy travel. So the point I'm trying to get at is stop making assumptions about people that, oh, because he's a person with disability or she's a person with disability, they will do something in a specific way, or they will not want to do this because they have a disability. Third and most important thing, when you are confronted with a situation where you are expected to be equitable and dignified with the other person, one of the things that we as humans do is to disown the problem. We think it is not our problem. If the opposite side lawyer or a litigant with a disability, for instance, is asking for a accessible copy of the pleading, the lawyer would think it is not my problem. Let this be done by the registry. Registry will say, I don't have the bandwidth, let the lawyer itself file an accessible copy. The point is that it is a shared responsibility that each one of us have to discharge to the extent we can. And it is an each touch point of justice delivery system where we need to think from an inclusion lens to make sure that inclusion is not just talked about but actually is realized in reality.
Right. So what's the one thing that you think must change immediately in the legal system? Because there are a lot of changes that are being made right now. I think the judiciary is working extensively on that. But what is the one thing that you think should change right now and and should be done immediately?
I think accountability of professionals towards the duty that they are discharging, it's that behavioral aspect that needs to change. Why is it that when the matter comes, when the court gives you a time to file reply and rejoinder in a given time, why is it that only one day before the next date of the hearing the opposite party files reply?
Right.
You have wasted that hearing because the party who has to file a rejoinder will have to again seek time from the court to be able to file a reply. Why is it that instructions are not taken before appearing in the matter either from the client or from the government? Why is it that you come to the court and say, I need time to seek instructions? That diligence, that sense of responsibility that today your actions, if led to wastage of judicial time, will not only cost you and the opposite side something, both in terms of money as well as in terms of the time, effort. At the same time, you are doing something or engaging in a conduct which is leading to denial of somebody else's right to seek justice.
So, how can we inspire people to take up law as a profession? People from all walks of life, because some of them think that law is not really meant for them, or some of them find it to be really scary. So, what advices would you give to such people?
For any profession to be seen in the right light, it is important to see the connotations that are attached with it, right?
Yes.
For instance, it is often believed that advocacy is a tool of conflict.
Right, sir.
Whereas, in my opinion, if used appropriately, advocacy is a tool to bring positive change. Right? Similarly, people feel that legal system is so complex that without having resources, without having right opportunities, one can't solve for it. But there are many in the society who have either given up or are not in a position to stand up for themselves. If you also think the same way, whereas you can stand up and own the problem and solve it rather than passing it on to somebody else, then why not take up and solve? That's the whole thing. Your thinking about law as a profession needs to change to see how can you use law as a profession for bringing improvements in the existing system or making the existing system better and turning it into something which works for everyone.
Right.
That's the thought process.
Thank you, sir, for being a part of today's podcast. We really had a great conversation. This was a really meaningful conversation.
Thank you so much for all the right questions.
So we learned a lot about how advocacy can be used as a tool to bring about change in the society. So the conversation that we had really inspired us to think from a different lens. Hope you had a meaningful and an informative session. Thank you so much for watching our podcast.